welcome to the Essential Liberties podcast. I'm your host, Jay David, and today we're going to take a look at Joe Biden's plan for your Second Amendment rights and what patriotic Americans are likely to do in response. If you remember on the campaign trail, one of Joe Biden's competitors for the Democratic nomination, Beto O'Rourke, told us, "Hell yes, I'm coming for your AR-15s. Hell yes, I'm coming for your AK-47s." Shortly after that, when Biden secured the nomination, he told us that we'd be seeing a lot more of Beto O'Rourke, that Beto O'Rourke was going to help him solve the gun problem. Well, let's take a look at exactly what Joe Biden's plan is for your Second Amendment rights and how Americans, patriotic Americans, are likely to respond based on the history of gun registrations and attempted gun confiscations in this country. From Joe Biden's own website, here's his plan to end our gun violence epidemic. Joe Biden starts out by telling us what our gun problem is. He calls it a public health epidemic in which 40,000 people a year die as a result of firearm injuries. Now, without getting into the complete breakdown of this, we can first say that 30,000 of those people are suicides, and that is extremely tragic. However, suicide, being a mental health issue, is not a gun issue. In fact, if we look at the suicide rates in the United States compared to other developed countries, we're about in the middle, which lets us know that guns or no guns, those people unfortunately will end their own lives. The 10,000 gun deaths that remain, we find that about 8,000 of them are due to gang violence. Again, that's an epidemic in our inner cities and has a lot of causes not related to guns. In fact, if we look at the crime statistics comparing New York City to London, in a country where private ownership, bearing of arms is almost non-existent, in fact, most of the police officers don't even carry guns, that in 2019, there were more murders in London than there were in New York City, in the United States of America, the land of the free and fairly unfettered gun ownership. The reality is that criminals will find a way, and most of those murders in London are also due to gang violence, but they're committed with knives and hammers and fists and any other implement that is available to those criminals seeking to do what they do. The statistic here also includes justified police shootings. It includes justified self-defense shootings. It includes also accidents, and then it does include a small number of murders. But let's take a look at what his plan is. The first thing is he wants to hold gun manufacturers accountable. So he references the assault weapons ban of 1994 and talks about how it reduced the lethality of mass shootings. Now, that doesn't make a lot of sense because if you take a look at what his ban entails, he talks about that this time the ban will be designed with lessons learned from the 1994 bans. For example, the ban on assault weapons will be designed to prevent manufacturers from circumventing the law by making minor changes that don't limit the weapon's lethality. So he's admitting right there that the 1994 assault weapons ban didn't actually ban the weapons that he's discussing. They banned certain cosmetic features to those firearms, such as flash suppressors, pistol grips, adjustable stocks, things that don't change how the weapons function. So despite acknowledging that that ban, which he claims credit for, and that sunsetted in 2004 under George Bush, it didn't actually ban anything about the weapon that would change how it was used. Yet he claims credit for it somehow working. The other thing that he plans to do is regulate the possession of existing assault weapons. And this is very interesting. The National Firearms Act regulates certain uncommon, designated as uncommon, specific weapons like automatic weapons. It also regulates noise suppressors and a few other items. What he plans to do is take your semi-automatic weapon, whether it be a pistol, whether it be a rifle, classify it as an assault weapon, and then regulate it by the NFA. And what that means is to own a firearm regulated by the National Firearms Act requires that you pay a $200 tax stamp for each item and submit to an additional background check. Now, what he's calling to be regulated is not just your semi-automatic weapons, but it also includes the magazines, which they categorize as high capacity, which we know are standard capacity, intended capacity magazines for these firearms. So $200 for each semi-automatic weapon that you own and for each magazine. Now, for some people, that could be thousands, if not tens of thousands of dollars. That's Joe Biden's plan to register, to either confiscate or buy back, or to make you pay $200 per each of those items. Some of the other items in his plan is requiring background checks for all gun sales. So what is requiring is that for you to have a legally owned piece of property, that you can not sell that property to someone else. If you want to sell that, you have to transfer it, which means register it, which means pay the NFA tax to own that particular item. A couple other things he plans to do. One is make the Social Security Administration turn over background information to the NFA, and that includes people that have been adjudicated to not be able to handle their affairs through the Social Security Administration. So if you can't pay your bills, if you can't handle your finances, for some reason, you shouldn't be allowed to protect yourself. He also plans to ensure that no one will be able to sell firearms, ammunition, kits, or even gun parts online. So the days of going online, finding a part, a sight, a scope, any of those things online and purchasing that will now be illegal. It'll have to go through gun stores where the mechanism of regulation and registration will be able to happen. Certainly he's in support of red flag laws, laws that allow courts to take somebody's firearms away without them being able to stand witness, to testify on their own behalf that should not happen. That's a violation of the Due Process Clause of the Fourth Amendment, and I think a serious consideration as well. That's what Joe Biden and presumably Beto O'Rourke, hell yes, I'll take your AK-47s, are planning for your Second Amendment rights. Now, here's what I believe. If we look in history, there have been attempts in this country, by states specifically, to carry out some of these infringements. One of those, most notably, was in Connecticut. New American article here published in January of 2014. Connecticut enacted a law that required all owners of semi-automatic weapons and high-capacity, again, magazines, which we know are standard capacity magazines, to register those firearms and those magazines with the state. Now, according to reports, there are about 50,000 assault weapons or semi-automatic weapons and 40,000 of the high capacity, i.e. standard capacity magazines that were actually registered with the state. Now that may seem like a lot until we look at what some of the estimates are as far as how many of those firearms are owned by the state. Connecticut's own Office of Legislative Research said that there could be tens of millions, as many as 500,000, and I've seen some reports that said over 1 million semi-automatic firearms existed in that state. So when you look at the number, even if we take 50,000 as the assumption, 50,000 being registered means that is 10%. That the other 90% of the people in the state did their patriotic duty to not obey an unconstitutional law and refused that registration. This is not the only time that patriots have stood up and refused unconstitutional gun laws. In California in the 1990s, there were an estimated 300,000 guns classified as assault weapons, and when mandatory registration was enacted, only 7,000 of those firearms were registered. Similar things have happened in Canada. Similar things have happened in many states throughout the United States. And generally, the line of defense, those who are drawing a line in the sand and refusing to enforce these laws, are the sheriffs. In almost all of these cases, the sheriffs, the law enforcement, in many cases district attorneys, have said, we will not arrest, we will not prosecute these people. In Washington, when Washington passed a universal background check, prohibiting private transfers of guns. There were well-documented "I will not comply" rallies. Those rallies were held on the grounds of the state capitol, where guns were transferred back and forth in defiance of the law. The sheriffs did not enforce that unconstitutional law. There were gun shows where non-compliance was encouraged. In Colorado, law enforcement officials almost universally said they would not enforce these laws. Retailers declined to process background checks for private transfers. Washington law enforcement announced that there would be no arrest for selling guns. We've also seen this in the state of Virginia, where the attempt to pass severe restrictions on Second Amendment rights led to a movement of counties to declare themselves Second Amendment sanctuaries where these laws would not be enforced. And that was the sheriffs in conjunction with local prosecutors who said, no, these laws are unconstitutional, which is exactly what they're supposed to do, which is exactly what you're supposed to do in the face of an unconstitutional law. Let's take a look at where that comes from. The precedent, the Supreme Court, the constitutional precedent for not complying with unconstitutional laws. First, let's take a look at what the Constitution says. As we all know, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. The key word there is infringed, and let's take a look at the definition. Act so as to limit or undermine something, encroach on. So encroach is interesting, right? That's a small step. That's not the outright ban. That's not the wholesale regulation. That they cannot come anywhere near it. They can't step 1 foot on our Second Amendment rights. And the Constitution being the supreme law of the land, and the Constitution not granting a right but acknowledging a universal right, means that your Second Amendment, your right to keep and bear arms, the right to defend yourself, cannot be questioned or infringed upon by laws. If we take a look at the Constitution in my state, in Section 21 of the Pennsylvania State Constitution, they're even more clear as to what this actually means. They say the right of citizens to bear arms in defense of themselves or the state shall not be questioned. So not only can't you infringe upon it, you can't even question it. So given that the Constitution of the United States, the state of Pennsylvania, and many other states is very, very clear, given that the Constitution of the state and of our country is the supreme law of the land, that cannot be infringed upon. Let's take a look at some of the precedent for disobeying these laws. In Marbury versus Madison, a very important Supreme Court case, all the way back in 1803, a case that really established the Supreme Court as gave them the power of judicial review, the power to take a look at laws and declare them constitutional or unconstitutional, a review that was not necessarily explicit in the Constitution, but this established the precedent for it. It says, a law repugnant to the Constitution is void. An act of Congress repugnant to the Constitution cannot become law. The Constitution supersedes all other laws, and the individual's rights shall be liberally enforced in favor of him. In the case Ex parte Siebold, back in 1879, part of that decision reads, an unconstitutional law is void and as is no law. An offense created by it is not a crime. A conviction under it is not merely erroneous, but it is illegal and void and cannot be used as a legal cause of imprisonment. Norton versus Shelby County, a case in Tennessee, 1886. So right from our founding, as people intended and attempted to encroach upon those supreme laws of the Constitution, the courts were very clear in declaring that those laws are no laws. Those laws have no force. They convey no obligation on the people. An unconstitutional act is not a law. It confers no rights. It imposes no duties. More recently, Miranda versus Arizona, a very well-known case from which we get our Miranda rights. It says where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. While the law has no force, if it is to have no force, it is our obligation as patriotic citizens to not comply with those laws so as not to give it force, because if we comply with it, it has all of the force of law as if it constitutionally did, which we know it doesn't. From American jurisprudence, kind of a compendium, I believe it was 140, 180 volumes, that summarizes legal precedent, legal decisions based on categories. It tells us the general misconception is that any statute passed by legislators bearing the appearance of law constitutes the law of the land. But the U.S. Constitution is the supreme law of the land, and any statute to be valid must be in agreement. It is impossible for both the Constitution and the law violating it to be valid. One must prevail. The general rule is that an unconstitutional statute, though having the form and name of law, is really no law but wholly void and ineffective for any purposes. It is as inoperative as if it had never been passed. No one is bound to obey an unconstitutional law, and no courts are bound to enforce it, which would lead to the fact that no sheriff, no law enforcement officer is bound to arrest people for it, and no prosecutor is bound to prosecute them for it. In fact, it is their duty to not, as it is your duty to not comply with unconstitutional edicts masquerading as law. So as we face the future, if we move into what looks like a Joe Biden presidency, and this law, this proposal from his website is an attempt is made to enact that into law. An attempt is made to enforce that on you, enforce that infringement of your Second Amendment rights, to force that into law. It is your duty as a patriotic American to not comply, as the citizens of Connecticut have done, as the citizens of California before you have done, of Colorado, of Washington, of many others. Because to comply with a law that disagrees significantly with the Constitution is to give it power. Any law, constitutional or not, if you comply with it, it has the force of law. It has the intended force because you're not questioning it, you're not resisting it. That is our duty as we move forward into what looks to be a scary time, looks to be a dangerous time for our rights in the Constitution, our natural rights, our God-given rights. We must call on ourselves and our friends and our neighbors to help them understand that obeying an unconstitutional law is the most unpatriotic thing that you can do. But resisting that law is your patriotic duty, defines you, in fact, as a patriot. And for all of our friends in law enforcement, all the prosecutors of the world, it is your obligation by office, by the oath that you took to the Constitution of the United States, to neither arrest nor enforce nor prosecute people for violations of acts that have no validity. Because when they violate the Constitution remains the supreme law of the land. So if we see in the future laws like this passed, those that comply are contributing significantly to the erosion of our rights. Those that don't comply are saying we believe in the Constitution, we believe in the founders, we believe in the principles of the United States of America. It is a patriotic act to resist the infringement of your rights. It is a patriotic act to resist any law that is repugnant to the intention of the Constitution of the United States of America. Thank you, my patriotic friends, for spending some time with me today. If you've liked what you've seen, please like and subscribe to the video. There'll be more great content coming soon for patriots, people who are looking to pursue life, liberty, and truth.